You heard me?
What you giving me?
Charging. 4499. And single watch around and with it. Not cheap.
He always go down and come right back. He just singing like that. I told you I paid you. Come on.
You are a unpaid interpreter.
Exactly.
Got it.
William, that's a cute name to get to. Unpaid.
He did the same thing last week.
Started the jail with mute.
Deputy, I need y'all to mute, please.
I've already muted them.
Thank you. Donna, would you like for me to start?
Well, Judge, it's our motion. I think it.
I think she froze again.
That's what last.
There she goes.
Wow, okay. Did y'all hear everything I said?
No, ma'am.
Oh my goodness, okay. And so he's charged with battery and simple assault. Attorney Rogers, your witness.
Thank you, Judge. Well, I don't know. He's not gonna be my witness. Can you hear me okay, Judge?
I can't, my apologies for that, yeah, okay.
Oh,
Go
yes.
ahead. Your motion is what I meant to say.
Yes, ma'am. So, Judge, a couple of things just to kind of, I guess, set the backdrop in this case. Mr. Alegria, my position is number one, he's entitled to a bond. He's been entitled to a bond. The charges on the calendar, they're misdemeanors. The charge with a battery and a simple assault. My understanding from the combination of speaking with Mr. Alegria, reviewing court case inquiry, speaking with the attorney, Ms. Hayden, in our office that filed the bond motion. That's where everything I'm about to say comes from, that combination, and also probably from my conversation with ADA Thomas. Mr. Alegria, like I said, is charged with 2 misdemeanors. He's been charged with these since April. So that's where my position number one is from, that he is entitled to a bond. Currently at the jail, he is showing no bond, but he's been in over 90 days, which is irrelevant because they're misdemeanor charges. But even if he were charged with a felony, he would still be entitled as it's been past 90 days. From reviewing the court case inquiry and from based on Mr. Alegria's recollection of first appearance, it appears that he was set a bond of totaling $4,500 for both charges. However, at some point, for some reason, which I have not been able to find any documentation, anything that would justify, allow, anything like that, the bond no longer shows up at the jail. Ms. Alegria is under the impression that the bond is no longer in effect. So I don't know what happened to that initially set bond. So that's kind of where I'm at in treating that almost as a baseline and treating this as a bond reduction here because, like I said, number one, he was entitled. There was one set at $4,500. I want to be more clear about it. What I'm asking for is an OR bond on the assault charge. In reviewing the law, the battery doesn't look like the court is allowed to set an OR bond on the battery, so I'd be asking that it be something pretty close to an 20, 50, something like that on the bond. Because while an OR bond is not allowed on the battery, there's no minimum requirement for it. As it stands right now, Mr. Alegria has been in. Now, granted, he had another charge. These charges stem from an incident at the jail, which that seems to be the state's position is that some combination, and I'm not just speaking for Ms. Thomas, and I don't even want to speak for her, but my understanding is essentially it started in state as a misdemeanor, state court or the solicitor or somebody decided that hypothetically it could be charged as something that is not charged as, and then at some point stuff gets upgraded or transferred, or whatever language they want to use. I've asked to see, some sort of filing, some sort of document, something other than this idea of some sort of shadow charges where people are unofficially charged with things that you can't find.
I'm going to object to the term shadow charges. There's an administrative procedure that is clear and relevant, clear and available to any individual who seeks to do research on it?
And Jan, I would object because the government don't get to tell me how to phrase my arguments. The First Amendment, I have freedom of speech. If I want to call them shadow charges, I can call them shadow charges. She can call them whatever she likes. First Amendment allows me to call them whatever I like, as long as it's not so disruptive.
Okay, all right, go ahead.
So, as I was saying, this idea of shadow charges where, again, if there's some sort of formal filing, show it to me. I haven't seen it, don't have any record of it. I've asked, the state to show me. Nobody's given me a case number, any sort of filing, pleading, anything of that sort. So as it stands, from everything I've seen, Mr. Allegria is charged with simple assault and battery. 2 misdemeanors. Been in 6 months. At this point, that's why I'm asking for essentially an OR bond on the assault charge and a $20 bond on the battery charge. If the government wants to fall back on the idea that it's free to, do all this behind the scenes stuff that's not publicly available, it's not a court filed document or something like that, I would ask for them to show the statutory authority, some sort of constitutional authority, some sort of basis other than they feel like it. Additionally,
How much is it simple assault?
that
Right
one
now,
currently is showing no bond. What I saw when I reviewed court case inquiry was it was set at about at 1,000, I believe, and this would have been in April. But now when I look on the jail screen and to Mr. Allegria's knowledge, no bond showing. Like I said, I haven't seen that there was any kind of motion to revoke the bond, change bond, nothing to support any of this kind of stuff.
And then what about the battery? How much does he have currently?
Nothing is showing on that one at the jail. But again, that one in April, it was set at 3,500 is what I saw. And again, that's based on the court case inquiry screen. Like I said, I'm covering. Ms. Hayden asked me to handle this month, so I don't know if some other documentation has been provided. I have not seen anything other than that. So that's pretty much my issue with it. Also, I would fall back on the fact that it's been since April that these charges were laid. It's been 6 months, so the government's twiddled its thumbs for this long. I don't seem to have accused it, indicted it, done anything with it. And now they want the court to come and, frustrate his ability to be released. But like I said, it's a jail charge. Mr. Allegria was in on something else. He's handled that case. The only charges that I see showing continue to hold him at the jail are these charges. To kind of get into it a little bit more specifically, Mr. Allegria is 31. He was working for Secure Protection Services doing security for high-profile clientele. He lives in downtown Atlanta in an apartment with his girlfriend, has a 5-year-old son, whose birthday was Wednesday. Also has a newborn daughter as of July the 27th of this year. And from speaking with Ms. Hayden, and I don't want to overstay anybody's position, but in speaking with Ms. Hayden, there seem to be some discussions, I guess, about possibly getting this resolved in Superior Court, and that it may have been, I guess the timing of the whatever was done kind of interfere with his ability to handle this part as part of the other case that he's already handled, which was like a weed charge or something. So at this point, Judge, the fact that he's been in 6 months, they're misdemeanor charges. To be even more specific about the charges, Mr. Allegria's position, our position is that whatever happened, these were defensive maneuvers. And that's kind of where we stand on that part of it. So for all those reasons, Judge, I would ask that the court set a total bond of $20. And that's our position, Judge. Thanks.
Go ahead, Ms. Thomas.
Yeah, Mr. Allegria was charged with initially with battery and simple assault for an assault on another inmate at the jail. If a person can't be safe in jail, where can you be safe? The case was sent initially to the state court of Clayton County for prosecution. Upon being received there, they evaluated the case and determined that there was actually a felony component to the case that they could not pursue. The case was administratively transferred to the Superior Court of Fulton, to the District Attorney's Office for prosecution in the Superior Court, a protocol which I'm sure the court and Mr. Rogers is familiar with. Upon receipt by our office, the case is currently pending grand jury for that upgraded charge of unlawful acts of violence in a penal institution, and battery. The simple assault charge will not be pursued by our office. That's the current status of the case. Now, what happened with the original bonds between then and now, I cannot say. However, the state would contend that a $20 bond in this situation where the victim, in this case, another inmate, sustained bruises, chipped tooth, and a laceration to his lip would be drastically inappropriate in this matter. State would ask that the court set a bond on the penal acts in a penal institution, set that one at $10,000 and a $5,000 bond on the battery. Thank you, Your Honor.
Okay, well, I can't, the penal institution charge is not before the court, so I can't set anything on that. That's not before the court right now. All right, and so you're asking for how much, Ms. Thomas, on the simple assault?
The simple assault that is still pending before the court, Your Honor, state would be asking for a $1,000 bond on that one. For the
Okay.
battery itself, I believe I indicated 5.
Okay, and so tell me a little bit about his criminal history.
Yes, ma'am. His criminal history, now he has a conviction from this year for possession of marijuana less than an ounce and false information. And that is pretty much it, Your Honor, other than these outstanding cases that occurred in the jail.
Okay, anything else you want to tell me, Ms. Thomas?
Just very briefly, Your Honor, from what I can tell, he was initially arrested for the charge that he has now pled guilty to. But for this incident in the jail, he probably been released and on his way. So, Your Honor, if you can't maintain yourself in jail while waiting on the disposition of a case like this, Your Honor, a $20 bond would not be the appropriate bond for you. You present yourself as a risk and a danger to the public and very likely to yourself if you're committing crimes in the confines of the jail. State would ask that the court, in taking all of this in light, set the bonds of $5,000 on the battery and $1,000 on the simple assault.
All right, final words, Attorney Rogers?
Thank you, Judge. Couple of things I'll say about that. For one, the state's putting the cart before the horse. Mr. Alegria has not been convicted of those things, but yet they're asking the court to assume his guilt on the front end and then treat him on that basis. That's not how it works. That is not the order of operations, as the phrase is from my math classes. That's not how it goes. He's innocent. He has not been proven guilty. Number one. Number two, this idea that, about people supposed to be safe at the jail. That's why Mr. Alegria wants to get out, because the jail ain't safe, Judge. So, that's just a ridiculous idea that people are supposed to be in the jail just kicking it and be all safe and everything. Like we said, it's our position that Mr. Alegria acted in defense. Just because you lose a fight don't mean you didn't start the fight. You know what I'm saying? That's not how it goes. That's not how you determine who's in the wrong is, oh, did you get the worst of it? Well, then that makes you the victim. Nah, you can be the aggressor and still get whooped. So that hasn't been determined yet, Judge. So if what the state has to fall back on is asking you to assume his guilt and with no basis to say that, he's got any sort of record of this, then the state don't have much, is my position. So for those reasons, Judge, I would ask, like I said, a $20 total bond for Mr. Alegria, because they didn't even offer some sort of history of violence, anything like that, or anything of the sort, Judge. And again, 6 months he's been in. Should have had a bond this whole time. And I'm not, I'm certainly not saying that the state played any part in that aspect of it or anything. But my point is, not accused, not indicted. It's been 6 months. He's been in without the opportunity to make a bond. So at this point, the idea that the state would ask that you to come and set a bond higher than the one he was given initially at first appearance, with no explanation for why that bond went away, and no basis to raise it or anything of that sort, I just don't hear any argument that is persuasive. And so I would ask that the court set the bond at $20. Thank you.
All right. All right, the court sets the simple assault at $150 and the battery at $250 for a total bond of $400. That's the order of the court.
Thank you, Judge.
And so, Ms. Thomas, you're going to, and make sure if there's a well, make sure that inmate name is in there as the stay away when the bond is proposed. So that's $150 on the simple assault. And I did this primarily based on the time that he's been in there, because at this point with no prior battery charges, if he pled to those, he would get time served and he would be on his way, likely. So $400 is the bond amount. All right, so who do we have next?